Good afternoon, everyone, and welcome to our webinar on Employer Update 457 Visa Review Report. Thank you for joining us. My name is Kerry Ann McLeod, Events Coordinator for New South Wales Business Chamber, and I will be your moderator for today. I'm joined by Alexander Walk, Director of Sydney Migration International, and Shane Welsh, Migration Lawyer for Sydney Migration International. Good afternoon, Alexander and Shane.
Good afternoon, everybody.
Good afternoon, everybody. If you have any questions today, please submit these via the chat box on the bottom left-hand corner of your screen, and we will endeavour to answer as many as possible throughout the presentation. I will now hand you over to Alexander and Shane.
Okay, good day, everybody. My name is Alexander. I'm the Director of Sydney Migration International, and I'm joined with Shane here today. And first of all, thank you to the New South Wales Business Chamber of Commerce for giving us the opportunity to present and to update you and your businesses on the newest changes regarding the 457 visa update and review results, which were published last week sorry, by the department. First question, can everybody hear me clearly? Somebody could please type something into the chat. I would appreciate that. Otherwise, I have to assume that nobody can hear me. Yes. Okay, good. Here we go. First of all, a little bit of background information who we are. Sydney Migration International was founded in 2009, and we are specialized to service small and medium-sized businesses. So the only thing we do is basically we provide visa services for businesses and skilled individuals who wish to work and live in Australia. Over the last years, we have opened further offices Australia-wide in New Zealand, in North America, and in Europe, and still we follow the same principle. The only thing we do is we provide services for people who want to live and work in Australia. The agenda today. The purpose of this presentation is to highlight issues around the current 457 visa program, and I'm pretty sure you may have read or heard about the changes which are in the air, may come or may not come. It's a topic in the news and in all the magazines. And we want to offer solutions to avoiding business obstacles that may occur when you are sponsoring overseas employees. So the agenda, we talk about the 457 visa program. We try to give an update on the announced review and the department's response, the things which are going to happen in the short term and the long term. And then we may be able to offer some alternatives, some alternative pathways to avoid actually the 457 issues. I'm happy now, if there are no further questions, to hand this over to Shane, who is bringing us an update regarding the 457 visa program.
Okay, guys, being happy to talk over the 457 visa with you first. But first, just to get an overview, it would be good to do a polling question. Just to see how many of you has your business actively sponsored an employee from overseas before? Okay, so looking at the majority of the answers, it seems as though you have had some experience with the 457 program. So I'll be able to, so it's good that we can go from that and move forward. So basically, as many of you do know, in terms of the actual program itself or accessing, employing someone from abroad, you will have to have the requisite authorization from the Department of Immigration and Border Protection, also known as DIP, and that's not only for the visa holder themselves or the prospective employee, but the business. So what we're finding is, despite a tight labour market, a lot of employers are still finding it difficult to find the right employee within Australia. So as such, they're looking at other avenues to employ individuals who are skilled in certain areas which Australia just can't meet the market. So a lot of the time, people bring people across on 457 visas, which is a temporary visa, or on employment nomination scheme, which is 186, so that's permanent, as well as regional skilled migration scheme, just depending where the sponsor themselves are located. I suppose the major benefit of hiring someone from abroad is that you're actually finding the right person. So, for example, in the current financial year, there's been approximately 50,000 grants alone. And the majority of these, we understand, have been given to small and medium enterprises, business enterprises. So although what we find is that a lot of people say that it might seem daunting, but this sort of indicates that it can be done. And I suppose one of the major benefits as well of accessing any program from sponsoring employees overseas is that you don't lose the business advantage that other people are gaining. So moving forward, as many of you do know, the program is broken down into 3 steps. So we'll touch on those lightly throughout the presentation. So sponsorship, nomination, the visa application. Then I would also like to talk about the common stumbling blocks that people come across with the 457 program. So one of those is the training benchmark, which is an issue that comes up again and again, as well as actually finding an occupation to sponsor somebody on. It has to be on the Consolidated Sponsored Occupation List, or CSOL, if you're going to use the immigration lingo. Also, one of the stumbling blocks or hurdles is ensuring that the prospective employee is offered equivalent terms and conditions of employment. So market salary rate, meeting TISMIT, as well as doing labour market testing when that is required. Okay, and then as many of you would be well aware as well, with the 457 program, sponsors have obligations which are enforced by the department. So some of these, which we'll touch on later, to ensure that the visa holder participates only in the nominated occupation, that you're not allowed to recover costs or transfer costs associated with becoming a sponsor to the visa applicant or their family, as well as the obligation to keep records, cooperate with the department inspectors, as well as update them when certain events occur. The last one we'll also touch on are the travel costs, which occurs if your employee happens to become unlawful. Okay. So in terms of the sponsorship stage of the 457 visa program, the sponsor must be a lawfully operating business, must meet the training benchmarks, agree to a certain number of 457 workers to be nominated. They'll have to outline that in the application itself. Also ensure that there's no adverse information against the actual business itself. And then you'll also be able to, must be able to demonstrate that you have a commitment to employing local labour, as well as non-discriminatory recruitment practices, which is a hurdle some of our employers or clients find a bit difficult at times. When it comes to the actual entity which is able to sponsor, the department doesn't really discriminate. There's partnerships, companies, trusts, sole traders, provided that you're not actually going to employ yourself, because you can't fire yourself. That's their rationale behind that. In terms of some facts for 457s, the quarterly report, which was released in December, there's one due out shortly because of March. Just in that quarter alone, there was 25,000 grants given, but 60% of those 60% of 457 visa holders go on to ENS. So that's 60% of those actual people holding a 457 moving on to being nominated by an employer. So that's sort of double ups on the costs involved. So Alex will be talking about sort of remedying this situation a bit further down the track and sort of saving money for businesses. In terms of commitment to training, to meet this, you'll either have to demonstrate that there's been a recent expenditure of at least 2% of payroll to the business to an industry training fund. So basically, you look at your payroll for the past year, get 2%, and then throw that amount of money to an industry training fund to assist other people train other Australians within, I suppose, recognised programs. A lot of our clients tend to not want to waste that money, so what they do is they opt for training benchmark B. So that's when you have recent expenditure to the equivalent of at least 1% of payroll of the business in the provision of training your own employees who are Australian citizens or permanent residents. So some inclusions for this might be, for example, a receipt for a formal course of study for your Australian employees. They don't actually have to partake in that course as of yet. There just has to be that recent expenditure. Also, what a lot of our clients like to do is include expenditure for the employment contracts of their apprentices, trainees, or recent graduates that are hired with the business on an ongoing basis, as well as receipts from external providers who deliver training to your Australian employees. When it comes to the nomination stage, the department sort of shifts their view, and what they're looking at is that the position itself is going to be genuine, that the person that you're looking to sponsor actually has the skills and qualifications to do the role within the business, and that the actual business needs this role to do their operations. They'll also look into where the employee will be working. That's location within Australia, because that sort of leads into the market salary rate, things like that. So as I touched on before, to access the 457 visa program, what a business must do is nominate an occupation that's on the consolidated sponsored occupation list. So this is a pretty extensive list of over 600 occupations, and basically it just gives a bit of guidance from the department as to what businesses can bring people across on. So basically, what we find is a lot of the time people are looking to bring someone in on I don't know, a certain occupation, but they can't sort of match it up to this list. Basically, it must be reviewed that the government will be looking at the substance of the role over the title that you give the person. So you might give them a spectacular, crazy title, which would make them feel really chuffed as an employee. The department doesn't care about huge titles. They're more about what they're actually going to be doing in your business. So if you say that someone's going to be a manager of the Asia Pacific region of your conglomerate company, and it turns out that it's just being a chef with some admin duties, the department's not going to be too happy. So yeah, they will be considering the actual tasks that will be performed by the person. In terms of labour market testing, this is a requirement. It just sort of waxes and wanes depending on the government which is in power at the time. So it's come back again in November 2013, and it was done to promote the recruiting from the local workforce. So employers may be required to test the local labour market prior to lodging a nomination application, and may be required to evidence such attempts. So some exemptions do apply, so where Australia might conflict with one of Australia's trade obligations, or if the nomination is lodged by parties to a labour agreement. But for example, some of our clients which have required labour market testing in the past are those like engineers, nurses, cooks, bricklayers, property managers, real estate representatives, and the list sort of goes on. The department has looked into changing this, but again, this is something Alex will touch on a bit later as to what sort of recommendations have been made. So again, in ensuring equivalent terms of condition of employment, basically it's to make sure that the workforce is not undercut, the local workforce, and that foreign employees are not exploited. There's been this recent case where down in Tasmania, an employee was only paid $2 an hour. So the department's looking to weed out that sort of exploitation of foreign employees. So at this stage as well, what the department will look at is there'll be a consideration of the collective agreement or award that protects the worker, and also if the terms and conditions are in line with the market. So often they'll be looking at as well the national employment standards, which affect all Australians who work at employees. They'll also have an examination of if the offered salary is equal to or greater than TISMIT. So that's to actually access the 457 program, there's going to be TISMIT, which is $53,900. Basically, that's the figure that the government has decided that people can support themselves within Australia, and also allows people to access the program. So can't pay any lower than that, otherwise can't get into the program. That that figure is set to increase in July by KPI or CPI. Sorry. So continuing on with ensuring that equivalent terms and conditions of employment. Yeah, as I just touched on with the 53,900. So the onus is on the employer to provide evidence that the salary is above TISMIT and that the terms and conditions of employment are no less favourable than the market salary rate. So often what our clients do is they get a breakdown of job advertisements on Seek and in the same area or other websites that could begin to Seek, and just sort of try to prove that yes, they are actually paying the market salary rate. This is a sort of a strange creature because depending on who you're going to ask, there's going to be a different rate. So it's really basically on the onus is on the employer, and the more information that's forwarded to the department to bolster the application, it's going to be better to make the application run smoother.
I just want to read out 2 questions we have received. Sorry for the interruption, Shane. I think this fits a little bit. Leanne asked if my company has just been brought out and I would like to get him a visa, would I go for a 457 visa? The answer to this is basically, it depends. You could decide to sponsor him on a 457 visa or under the employer nomination scheme. We will talk about the pros and cons in a few minutes. There was also a second question from Carl asking whether there has been updates on agents receiving commissions in referring 457 benchmarks to a training fund, benchmark A. Shane mentioned that beforehand, and we will provide those updates also in a few minutes. Thank you.
Okay, so this slide now refers more so to the 3rd stage of the application, so visa application stage. The department will be looking at the skills and qualifications of the employee, but it will also just make sure that they can speak vocational English to get around Australia, also that they will meet health and character requirements. Basically trying not to let criminals or crazy people into the country. Moving on to sponsorship obligations, as many of you may be aware, this is something that the department sort of puts onto people who want to sponsor from overseas. And our clients in the past have sometimes said to us that they can be slightly onerous and a bit difficult. So going through them now, the first one, which often is a bit difficult, is the visa holder is to participate only in the nominated occupation. So basically, in this fluid market at the moment, we recognise that a lot of people hire somebody with the intention that they'll do one role within the company. But as the company or business changes and their model changes, their role may vary, maybe a little bit, maybe a lot. When it does change a lot, I suppose it really depends on case to case. A new nomination application must be lodged to support that position within the company. This onus is on the sponsor to ensure compliance. So basically, everybody at the top has to make sure that they know what their 457 visa holders are doing, just to make sure that they're compliant with this obligation. Another one which a lot of our clients are surprised by is that there's a they're prohibited from recovering costs from the visa app holder or their family members. So that's costs that are related to the sponsorship and nomination. So if there's been recruitment fees, migration agent costs, or the actual fees to the Department of Immigration and Border Protection, you can't actually recoup those from the visa holder. It's just a no-go zone, and the department is pretty strict in that regard. Also, sponsors are obligated to keep records and to cooperate with the department inspectors. So basically, sponsors must show records to demonstrate compliance with obligations. So they must be able to, when they're asked, provide access to department officers to come into their premises, also produce and provide documents within the requested time frame, not preventing or attempting to prevent access to a person who is custody of or access to a record or document, or allowing access to an officer to interview any person. Basically, it's just to provide complete transparency within your business to the department, and they have the ability to have a look through all of the paperwork to make sure that you're complying with these obligations. Sponsors are also obligated to update the department of certain events and when there's been changes in circumstances. So, for example, if there's been a change to your business trading name or your ABN or any other business details, it could even be as simple as your contact or address details. You're also obligated to provide corrections to information you may have erroneously provided in the initial application. And then you'll also have to update the department if an employee is no longer sponsored by the company. So in regards to updating the department, one case we've had recently is there's been a transfer of, basically for tax purposes, a change of owner in the company. So it moved from one person to another. Nothing's really changed at all. The operation's the same, everything's the same, it's just the actual entity. This is obviously a major change, needs to be updated to the department, and changes need to be made to make sure that everybody's compliant with the program. Another obligation is that sponsors must pay travel costs to enable sponsored people to leave Australia. So basically, if the relationship between the employer and employee breaks down, and if the employee requests in paper to the employer that they arrange for them to go back, the sponsor must comply with this under this obligation. So basically, it's travel from the sponsored person's usual place of residence in Australia to the departure place from Australia, as well as travel from Australia to their own country of passport. So an economy class air ticket, or the regulation says a reasonable equivalent, whatever that may deem to be. Also, the business is obligated to pay costs to remove any unlawful non-citizens. So if there's a major breach completed, done by one of your sponsored employees or their family members, then the business itself is up for the costs incurred by the Commonwealth in locating and or removing that person or persons from Australia. And I believe that that's currently capped at 10,000 Australian dollars. So it's an expense that most employers wish to avoid. So just as a quick overall for the 457 program, I just didn't want to be all doom and gloom about it. There are some advantages to the program, is that it's relatively quick, skills assessment are rarely required, the applicants depend on the position of the business to keep the visa valid, so basically allows them to continue their relationship together, and the overseas individual may bring their family to work or study in Australia as well. So in terms of the change coming to the 457 visa program, I'm just going to cut across to Alex now, who will bring across all the changes for you guys. So thanks. Alex.
Thanks, Jane, for the overview of the 457 program. I mean, we have listened now almost more than 20 slides to Jane's view and basically the obligations for you as representing your businesses in regards to the 457 program. And the complexity was actually independently reviewed some last year and the year before last year, and what most sponsors, most businesses actually said they were not happy with the length of the SDS, the standard business sponsorship, which needs to be reviewed every 3 years, which actually means there are costs and bureaucracy involved for each and every business. The training benchmark, the complexity of showing that you train your people, avoiding costs at the end of the day. The time frame, and I see there is a question from Anne, how quick is relatively quick? Relatively quick can vary between 4 or 5 days up to 2-3 months. It depends how the application is actually prepared, lodged. If you go through the 3 steps simultaneously, or if you do it step by step. So that's the time frame answering that question. One of the always upcoming concerns from an employer's perspective were the labor marketing testing requirements, and it was clearly committed. We see this in our own client database as well. Most of our clients are not happy with the current labor market testing requirements. So having said this, the recommendations made in regards to the training overall were to consider actually not simply to apply a percentage, currently 1 or 2% of the complete payroll, but actually to incorporate a view in regards to the size of the business, which is going to sponsor, let's say there's a small, less than 20 employees business, or medium-sized business, or large-sized businesses. So that was published, and a few days, so to speak, later, last week on the 18th of March, the government responded officially by publishing more information. So the department actually published their intention that they want to support the findings of the independent review, which was undertaken in 2014. And they want to act on the recommendations by considering to increase the length of the standard business sponsorship from 3 to 5 years, and for startup businesses from 12 to 18 months. So this would actually mean that there is a significant cost reduction for businesses who wish to sponsor. The training overall may be replaced with an annual training fund contribution. We touched base on that one page beforehand. The labor market testing should be altered to reduce the burden or the red tape to employers. And the new penalty is introduced, making it unlawful for sponsors to receive payment in return for sponsoring a worker for a 457 visa. Also, the department promises to incorporate greater communication between the department and the Australian taxation offices for 457 visa holders. So this, in our view, is not only good news for employers. Moving on, the department also promised to change the English requirements to an average score. That's their intention. Currently, every visa applicant must provide an English test score in each band, and they consider reducing this to an average score. This may be easier for you to actually sponsor people from overseas who struggle to overcome the English test hurdle. Before refusals are made, the department may contact sponsors to provide further information to the decision maker. So a lot of visa refusals have actually been put in place over the last 12 months without even contacting the businesses or the sponsors to discuss the matters or background information. The department also wishes to consider the visa application charges and the age limitation for transition to ENS visas. It's important to say at this stage that the basic straightforward recommendations may occur over the next 6 months, with complex recommendations requiring further investigation estimated to come into force in 2016. So to sum this up, what we have here are intentions. How it's going to be detailed in the regulations, we need to await, and we need to be aware of what the department is going to implement and how it looks in detail. The alternatives to a 457 visa program. We want to touch base on that as well, because it seems the complexity of the 457 visa program and the advantages of the 457 visa program, they are clearly in place, and Shane touched on those. But we hear from a lot of clients, actually, can we bypass the complexity? Can we bypass certain things? Is there a better option available for us from a business perspective view? Saving money, saving time, saving effort. And we believe there are streamlined options available. One is the employer nomination scheme, the subclass 186, and the other one is the regional sponsored migration scheme. The above applications are composed of a two-stage process, simply a nomination and a visa application. So a standard business sponsorship is not required. The benefits of a subclass 186 or 187 visa are: the employer, the sponsor, you are not bound to the 457 sponsorship obligations. Those were the 20 pages Shane talked about earlier. There's less paperwork involved overall. Applicants may pay all costs, thereby saving costs to the business. We see that numerous of our clients are actually using these pathways to gain a financial advantage in regards to their competition. It allows the suitable employee to work with the company in a short period of time. The visa grants permanent residency, so there are no repeat applications. It saves the business money and future hassle, and it avoids disruption to the business. There are even more benefits. Employees and employer are not tied together. For instance, this doesn't mean that there are costs involved if you want to terminate the engagement with the employee and the employee has to leave the country. The employer commits to maintain the role for 2 years, which is not equal to keep the employee. You just need to commit to keep the role for 2 years. In return, the employee commits to stay with the employer for 2 years. We already said no repeat applications necessary, neither for the business, nor for the visa application or the nomination, because it grants permanent residency status straight away. It is a motivation for employees, and it even gives the employee and their family members access to Medicare. The subclass 186 and the subclass 187 visa can be entered directly. So you're able to use direct entry stream to access both programs. Your future employee can be inside or outside of Australia. We hear very often something which we call the 457 myth, something like, I need to employ an employee for 2 years on a 457 visa before I can actually switch him onto the ENS program. To make this very clear, you can sponsor your future employees directly without going through the 457 program if you wish to do so. The details of the employer nomination scheme. You can nominate a skilled worker for the visa if you actively and lawfully operate a business in Australia and have a genuine need for a paid employee to fill a skilled position. You offer that skilled position in the applicant's field that is full-time and ongoing for at least 2 years. You pay the market salary rate and comply with Australian immigration and workplace relation laws, and there is no adverse information known about your business. So those requirements actually fit on one page compared to the obligations which were explained over 22 pages, I believe, by Jane. The same applies to the regional sponsored migration scheme, subclass 187 visa. It's the same requirement. The only difference between those two streams are that the ENS visa applies to all cities, Australia-wide, whilst the regional sponsored migration scheme applies to regional Australia, which does not include the Gold Coast, Brisbane, Newcastle, Sydney, Wollongong, Melbourne. Otherwise, they are very much comparable. We have reached now the end of this presentation, and Jen are here to answer questions. If you want to raise questions in the audience.
Okay, so I've noticed that a few people have asked questions throughout, one of which is what happens when an employee on a 457 visa is made redundant? So in this situation, as always, we tell our clients that you have to comply with the relevant Australian workplace laws, give obviously the leave, or give all their entitlements that they have, but then also be able to tell them, you have no obligation to tell them that you can send them back overseas. It's only up to them themselves to write to you and ask to come to be sent abroad. Okay. We also have a question, what is the current age limit for transition to ENS? So basically at the moment what we have is a situation where people are on the 457 program, but they can't jump across to the permanent stage because the current, most of the time the cutoff is 50 years of age. In this review, which Alex was talking about earlier, there was also some in regards to that about changing to the 186, but it was only very briefly mentioned in the review, and actually not much has come from it. So the government will be looking into different options available for people under that situation. So I've got another question asking, is there any other list of occupations for a direct entry stream, or is it the same as CSOL? So what a lot of people tend to get confused with is for permanent visa applications, which people apply on their own merit as opposed to requiring an employer, so skilled independent, that relies on the skilled occupation list as opposed to the consolidated sponsored occupation list. It's ridiculous that they sound the same, but that's what we're with. But for direct entry, it's going to be CSOL as well. I suppose the difference is that for direct entry, you'll also need skills assessment. Okay, looking at other questions here. So it says, in regards to the current training benchmark, under the current system, I believe there is a limitation on how much money can be spent on the education of owners. Is this applicable to micro business? Our business has a total of 5 employees, including 2 owners. Okay, so basically in this situation, the department is trying to ensure that the wider population trained, that wider population of Australians or citizens or permanent residents are being trained. So there are some limitations on training just directors of companies. So it really depends on how the business itself is structured as to whether or not those people are employees or owners. But it's best that it's the employees who are Australians are trained and that you can actually show that the training has occurred, it's quantifiable, and there's a dollar amount that basically can be sent across to the department that's been incurred. Someone's also asked, is there any significant changes to the benchmark A and B contributions? So at this point in time, what the government is looking at doing is a lot of these changes that we've mentioned, they're going to be enacted probably within the next 6 months, with more of the complex situations being enacted, I suppose, by 2016 or in 2016, the department had mentioned. So at the moment in time, we've still got the training benchmarks A and B, but hopefully they're looking at streamlining this and making it more I suppose, easy for people to understand and just to pay across to a fund instead. So we've got another question as to why more businesses don't do a subclass 186. What are the hurdles, barriers, negatives to successfully getting a subclass 186? So a lot of the time when we've discussed with our colleagues about this way of going forward, as opposed to relying on the 457 program, is that a lot of people just overlook this option being available. A lot of them just forget that you can go straight to 186 using the direct entry stream. One of the things that I suppose that would be a curtailing factor would be that there is that age limit of 50 years, as well as you would have to demonstrate that you've got a skills assessment. So that's different to the 457 program. It just really depends on the amount of time that you have available. And Alex has to mention something in regards to this.
Yes, thank you. There was a question from Maria, and I think she has a point. She's asking that, on her understanding, the direct entry under 186 visa is that the applicant needs to complete a skills assessment. And she is asking that this may be very complex and difficult, and therefore may be a hurdle for a direct 186 access. That's a good point, Maria, and as Jane just mentioned, it is one of the things which need to happen. But on the other hand, we can actually see that most of our clients wish to do this anyway after the 457 visa is granted. Employers are paying thus kind of double costs for the 457 application, then the skills assessment, and then the 186 visa transition. As Shane said in the very beginning, more than 60% of 457 visas are eventually transferred into a 186 or 187 visa. So based on our experience and what we see, we cannot really confirm it is that complex and difficult. It can be done in 1 to 3 months. Most employees wish to do it anyway. So we can only recommend at this stage you may want to consider this as a second option to avoid the complexity if you feel it is complex to fulfill the obligations under the 457 visa program.
All right, thanks for that, Alex. We also have another query. What are the implications for an individual themselves if they leave employment before reaching the 2 years of being sponsored on the 186? So a requirement of every, I suppose, person that's on a visa is that they comply with the conditions which are given to that. So one of the ones on 457 is that you're basically tied to your employer for the validity of your visa. So 457s typically go for 4 years. At the 2 year mark is when you're eligible to apply for permanent residency. But should the employee wish to leave prior to that, that's completely fine. The department recognises that sometimes there will be a breakdown or somebody will want to go back to their country or go to a different company. But if they want to remain in Australia and they've left the company, they're not complying with their visa condition anymore, and basically they'll have to either find another way to remain in Australia, whether it be like a visitor visa, a student visa, or find another employer who's willing to sponsor their stay in Australia. I believe they've got around 90 days to do that after they've left their employer, but it's not really a great situation for them to be in. Okay, and we've got another question here. Yeah. So can an employee move to another employer? Yes, I've just indicated that. So one of the tricky sides of this as well is if somebody wants to move employer, but within their visa validity. So just say they leave 1 year into their 457, so they've got another 3 years. what they can do is go to another company, and provided they're doing the same position, all the new company will have to do is the sponsorship stage and nomination stage, and the visa applicant can bring the remaining 3 years of their visa across to that company without issue. So, of course, always updating the department along the way, making sure that they're aware of all of these changes. Okay, we have another question here. If someone on a 186 wants to get PR through his employer, does the employer have to qualify as a sponsor with regards to the training amount spent? So I'm just going to assume if somebody is on their 457 wanting to get PR, because the 186 itself is permanent residency. So the employer, as well as Alex touched on earlier, for a 186, there's requirements that they do have to meet. So it's more of a streamlined process in that there's only the nomination stage and visa application stage. At the nomination, they'll look at the company, make sure that they are doing the training, also make sure that they're operating lawfully and things like that. But I suppose it's more streamlined as opposed to the 457 in our opinion. Okay, we also have another query where, as an employee, is there an obligation to inform immigration that they no longer work for the company? And do you think this will change? So in terms of the review that was put forward, it wasn't within the scope very much so for them to discuss about the obligation side of things. So it's unlikely that this area will change much because of the review. But in terms of the employee's obligation, they are required to update the department of changes in their circumstances. So a great example is a lot of the time when, someone comes across and brings their partner, that relationship breaks down, and then they forget to tell the department about the breakdown of that relationship. It may cause troubles down the track because you haven't kept the department abreast with all the changes in your situation. So definitely in terms of if your employment relationship breaks down, you should update the department as to that change in circumstance as well. So someone's asked for more clarity as to the training requirement for the 186. What I was meaning was with the 186, there's also the requirement for them to meet the training benchmarks. That's the same across the board. So the training benchmark A and B at this stage until the changes are brought in by the department. Someone's asked, how long does an employee have to be on a 457 before they can apply for a 186? And then can they apply directly, or do they need an employer to nominate them to do so? Okay, so we've encapsulated a few things there. So in terms of if they've already got an employer and they're on the 457 visa, they'll have to work with that employer for 2 years. At the end of that 2 years, the employer will have to agree and say, yep, this guy's a great employee, we're going to sponsor him for the permanent stage. And that's when, for the temporary transition stream, is when they can apply for the 186. Alternatively, for the 186, you still need the employer, but you can access it through the direct entry stream. So that's avoiding the 2-year requirement. It just really depends on that first moment where the employer decides how to bring the employee into Australia. Okay. Okay.
I think we have addressed all the questions we saw raised by you. Thank you very much for the participation. If we have no further questions, and we don't see anything popping up in our windows here, I would like to thank you, to express our thanks for having the opportunity to present to the New South Wales Business Chamber, and like to hand this over.
Great, thank you very much, Alexander and Shane. We've covered a lot of great information today that I'm sure our listeners will take away, and also a lot of great questions that have come through as well. You will actually receive a copy of the slides as well as a link to the webinar on demand. So thanks everyone for participating, and if you do actually have any further questions, there are information about Alexander and Shane which are actually included in the presentation pack with the slides, so you can easily contact Alexander and Shane. I'm sure they'll be able to address any further questions for you. So thanks again everyone for participating.
Thank you so much.
All right.
No problem. So thanks very much again, Alexander and Shane, and thanks again everyone.
Thank you.